Welcome to Lawyers in the House with Motley. Wish you had a lawyer in the family? Now you do. Here's your host, Veronica Waters.
Welcome to Lawyers in the House with Motley on WSB. I'm Veronica Waters here hosting you into the house for another fabulous episode with two brilliant Motley injury attorneys. So glad to have you with us again. Pull up a chair. Make yourself comfortable. I think you're going to like our topic today. It's one that we hear about all the time. Some people like videos of them. In pop culture, they have become somewhat of a punchline or a running joke. And to other people, today's topic can kind of seem like a scam idea. But I'll tell you that for the people in this room, what we're talking about today is no funny business at all. Let's talk about who we're talking to today. Introduction time. It's Motley Injury attorneys Sarah Root and Mike Moran. Sarah and Mike, welcome back to the house.
Good morning.
You guys have had them in here with us before. You remember Sarah and Mike. We've done several episodes together. Now, Sarah Root is a graduate of Michigan State University, both undergrad and law school.
Correct.
So you're a Michigan native?
I am.
Yes. Okay. And what led you to law? I read that you were inspired as a little kid.
It's true. So at my sixth grade career day, I was torn between florist or lawyer. And I went to see these two speakers back to back. And the florist was kind of negative, saying things like, good luck seeing your spouse on Valentine's Day. You have to work a lot of overtime. And then I went to the lawyer immediately after, who was really inspiring and engaging. And I walked out of there like, I'm going to be a lawyer. And that was that.
That's incredible.
Yep.
Really, a florist and lawyer.
Yeah.
So do you love floral arrangements?
I do, actually.
Arranging flowers.
And I like to garden, so it's a hobby now.
I love it. Listen, first impressions really do matter, do they not?
There you go. Change
Good
my
luck
whole
seeing
life.
your spouse on Valentine's Day, kids. And let me tell you about the thorns, okay?
Sure.
So you became an attorney, and what I wanted to do today was also highlight something that from both of you, actually. Sarah, you said advocating for justice for my clients in need and getting them the results they deserve is very rewarding.
It is. Yeah. I mean, I think I've said this before. I come from a family with a lot of medical people, medical backgrounds, doctors, nurses, things like that. And I've never had the stomach for those types of things. So this is my way to help people who have been injured or hurt. Kind of the most immediate thing, of course, is making sure their medical needs are met. But then thereafter, they have so many obstacles financially with medical bills, or if they're not able to work, and just things that people don't anticipate. It's really rewarding to be there to guide them through the process, to just take that stressful element off their plate so they know that they can just turn to us. We're going to handle everything, and they can focus on getting better.
Were your family, all of the medical people in your family, sort of disappointed that you didn't follow them into medicine?
No, I think that was another thing from a young age when I'd about be passing out when my mom and sister are talking about medical issues. My mom's a nurse. My sister became a doctor. I'd be in the car like, stop talking about that, So they knew that was not going to happen.
Yeah, but now you're in a field where you're seeing injuries all the time.
Yeah. Yep. Yeah. And it is nice, honestly, to have those medical professionals as a resource when we encounter different injuries and medical questions.
All right. And when did you know you were doing the right thing, Sarah?
I always know I'm doing the right thing.
Yeah?
Yeah.
You knew from the beginning?
I mean, truly.
That you were in the right spot?
Yeah. The law, I love to read. So it was a natural fit. And I've always been grateful that this was the path that I chose. And I enjoy my work and I haven't regretted it.
Motley Injury attorney Mike Moran is sitting to Sarah's right. And welcome back to the house, Mike.
Thank you.
Mike Moran went to East Stroudsburg University for undergrad and New York Law School.
Correct. Yeah.
Where he got his JD?
I did.
Yes. Yeah. And so tell me a little bit about this quote from you. When a client knows you really fought for them in their time of need, you earn a friend for life.
Yeah, I think it's very true. I think Sarah and I think everybody at our firm takes these cases very seriously, and in turn work very closely with our clients, but that causes us to then take these things personally, right? And so when you take something personally or take it upon yourself personally, you tend to earn friends. And that's the way I look at this and the work that I do. And oftentimes I mean, ideally you want to part with a client as a friend, but when you earn a friend, it's certainly very rewarding, and that's what I enjoy about the job.
Now, Sarah, how long have you been an attorney?
2008,
Eight?
I think, is when I was licensed.
And what
Yeah,
about you,
beginning.
Mike?
Coming on 20 years.
20 years? Okay, so, and how long were you both with Montlick? Or have you both been with Montlick? Was it,
Mike's been there longer than me. I came in 2013.
okay.
I'm there 21 years.
Wow, so pretty much your entire career then.
That's right.
Yeah. And did you know, like Sarah, that you were doing the right thing and in the right place from the beginning?
Yeah, no doubt. Particularly with this law firm, yeah. I mean, I felt really at home and supported right from the beginning. I had just moved here when they took me in from the Northeast. And so, yeah, I felt right at home. It felt like a big family. So I knew right away I was at the right place. And
Yeah.
I knew I wanted to be in that field and helping injured people. And then this place took me right in as one of their own. And I haven't looked elsewhere ever since. I mean,
Were you inspired into law as a kid too?
well, my mom will tell you I was a soapbox lawyer. Yeah, I could make some arguments as a 5-year-old for sure. And so I knew kind of early on what I wanted to do.
This is why I should have extra dessert, Mom. Let me make my case.
That's right. Exactly.
I love it. Thank you so much for giving us those peeks into your lives. Montlick Injury Attorneys Mike Moran and Sarah Root. Welcome to the house, everybody. This is Lawyers in the House with Montlick on WSB. I'm Veronica Waters. And today we're talking about slip and falls. I've got an attorney friend who says that he thinks the phrase slip and fall is sort of a misnomer, right? Because people think you slip, you fall, you get a prize. Number one, they're in a section of law called premises liability, right?
Correct.
But to his point, it's not some game that you play. Although people will try to game the system and try to make up this stuff, we're talking today about folks who have had slips, trips, and falls and barely walked away with serious injuries.
Correct. Yeah, I think that's a common misperception. We have all seen those videos online, things that you talked about where people are trying to set up a scam. But what we encounter are very serious injuries. It's not necessarily just a slip and fall. There's a lot of different areas that are covered, but the premises liability term basically means you've been injured on someone else's premises because of some sort of a dangerous condition that you weren't aware of, but the property owner either was or should have been aware of.
Can I have a slip and fall at my own house or on my own property?
Do you rent? And that's, if it's a landlord tenant, that's a whole aspect of the law. And the answer would be maybe.
Okay.
That's if typically a landlord's not responsible for any injuries that you have once they surrender the property to you, unless they had undertaken some construction and did so negligently, or if it's at an area where you need to come in and go out of your home. And it's the only way in and out of your home. So, but mostly if you get hurt in your own home, if you're renting, no, you would not have a claim.
So it is I trip, I step into something, I fall, or something falls on me and I'm hurt, but it's always generally somebody else's property. Yes.
Correct, because ultimately the other person has to have knowledge of this sort of dangerous situation that you don't have knowledge of. And ultimately, we're looking to recover compensation for your injuries and damages. And you're not going to sue yourself for that type of claim.
Probably not.
So, and basically then the issue would be you're the person responsible for maintaining your own premises and keeping it safe for yourself and others. I think a lot of times when we hear slip and fall, it comes this idea that comes forward isn't necessarily what we're actually seeing or talking about. The question is, what did you slip on? If it is a true slip and fall, or did you trip and fall, and what was the item? I think a lot of people have this misperception that simply if they are injured on someone else's property, then that alone means they have a valid claim. But that's not accurate.
Yeah, I would absolutely think that. You're right. I would absolutely think that. So let's dig into that a little bit, Sarah and Mike. What do you have to prove then if it's not just that simple?
Sure. There's a lot of these are very, very difficult cases, and we're a national firm, and I'll speak a little bit about Georgia, but mostly they all kind of follow, every state kind of follows the same parameters. So the first thing that the law looks at is, well, what is your status? What was your legal status? Why were you there, right? And so they break it down. There's invitees, right? And an invitee is typically at a public place like a store. They're invited to come and spend their money and purchase things. So they have one that has the highest duty is owed to invitees. And then there's
because you're saying, come into my place, spend money with me.
Correct. They are owed duties. That the landowner or store owner, whoever it may be, is inviting them in with a promise, and the promise is that I will provide you with safe property or premises to walk on.
Okay.
And so that's the highest duty is owed to invitees. And then there's licensees. A licensee is like a social guest. It's normally not at a public place. It's a friend coming over to your apartment. And then there's a trespasser, and they're really owed no duties. If you're on someone's property, you weren't invited, you're not expected, it wasn't foreseeable, you're going to be there, you really have no right to bring a claim if you're injured on that property. So the first thing the law looks to is, well, what is your classification? Like, who were you? Why were you there? And so it's that, invitee, licensee, and trespasser. Every property owner really has a duty to maintain their property in a safe manner, but certainly it's the invitees that are owed that highest duty.
All right, so then explain this to me. How can you prove that somebody was negligent when I came onto their property? Right? I'm not the negligent one. I'm the one who got hurt. Or am I the negligent one? I don't know. Sometimes I know you guys always say it depends. Did you do something wrong? Right?
Exactly.
But how do you go about proving this? This has to be. You mentioned it's difficult, even though from state to state the parameters might be the same. But I can't imagine how hard this is.
That's very fact specific. So
Okay.
that's why it's important to contact one of us so we can go into questions and get a really good understanding of exactly what we're dealing with. Because very small differences in one fact pattern and another could make all the difference in the world in bringing the case. So, for example, let's say we have a slip and fall at a grocery store. That's a common thing that happens. We have to know, why did you slip? What did you fall on? Because we may not be able to pinpoint why this was there. If someone slipped in a liquid and it's coming from the freezer and the grocery store knew that this freezer was broken, ice has melted all over the floor, couple hours have gone by and they've done nothing to remedy the situation or put out some warning signs or clean it up, that's extremely different than the shopper who came down the same aisle 30 seconds before you spilled their water bottle.
And how would the store have known that?
Exactly.
Because they're not following around every customer with a mop and a broom.
Yep.
Okay. I love it. So we're starting to delve into how to prove a slip and fall case. Not as easy as you might think. We're talking to Motley Injury attorneys Sarah Root and Mike Moran. Stay with us. We'll be right back. Welcome back to Lawyers in the House with Motley on WSB. I'm Veronica Waters in the house with Motley Injury attorneys Mike Moran and Sarah Root. We are talking about slip and falls today and just how bad they can actually be. Mike and Sarah, you were just talking to me about how difficult these things can be to prove. For example, in a store where people might often say that they have had a slip and fall, you think it's obvious that the store is at fault, but maybe not.
Yeah, these cases, I like to think of them as like when I'm handling them, it feels as if I'm walking on a razor's edge. And the reason I say that is if you get hit from behind in a car wreck, it's a clear liability case. You can prove that case. It moves on to damages. But in this case, you have to prove knowledge of the owner of the property, actual or constructive. And the best way to do that is clearly by filing a lawsuit and getting down into the nitty-gritty of discovery. So there's things that need to be done. Preservation of evidence letters. Today we see there's cameras everywhere, of course. So you want to get an attorney immediately asking people to preserve evidence. You want to do some creative things. You want to perhaps, if it's a real static defect, a broken issue, you want to get some building department inspections. You want to get some 911 calls. You can get 911 calls to a particular store going back a year. And so you can see if this has been a really habitual problem area for them. It all comes back to their knowledge versus their defenses that they can launch. And there's an awful lot of defenses like contributory negligence. Did you see it before you fell? If you saw it before you fell, you can be told you have equal knowledge and a judge will dismiss your case. So these cases have a lot more defenses than other cases. And I think that's what makes them particularly difficult.
How hard to prove is a slip and fall case?
It's pretty difficult. As Mike was saying, all states have slightly different variations on the rules, but Georgia has quite a few defenses that would tend to favor the property owner. So, contributory negligence, if you're distracted like a lot of us are these days, looking at your cell phone instead of watching where you're going, that's an easy one right there. If there's an argument that whatever sort of dangerous thing you fell on or tripped on was open and obvious, meaning if you'd just been looking where you're going, you would have seen this thing and you should have been able to avoid it.
Pull your face out of your cell phone, people. We're talking slip and fall cases here on Lawyers in the House with Motley on WSB. I'm Veronica Waters, inviting you to come right back. Hey, welcome back to the house. Lawyers in the House with Motley on WSB. I'm Veronica Waters here with Motley injury attorneys Sarah Root and Mike Moran. We are talking about slip and fall cases today and just how hard they are to prove. Let me tell you, it's been eye-opening so far in the first half of the show. If you missed any of it, don't worry. We got you. Just make sure you subscribe to Lawyers in the House on your favorite podcast platform. And that way, when the new episode drops, it's going to come right into your earbuds so you don't have to miss a thing. We're always available online at lawyersinthehouse.com, where you can also send us a note 24 hours a day, 7 days a week, or watch us on the YouTube and see our smiling faces. And remember that you can always find us on social media, too, in between each and every show. Just hit us up at Motley Law. Slips, trips, and falls are what we're talking about today, Sarah and Mike. And you said they are desperately hard to prove. Let's delve into a case together. I know that you two actually worked on a really big one together. Please tell us about it.
Sure. So this was probably about 10 years ago because it came after that major ice storm that we had in Atlanta at the time. And normally, slip and fall cases on the ice are not necessarily valid claims that we would pursue just because everyone has notice of the icy conditions. It makes it a little bit more difficult. But this case had some unique facts. Like I mentioned before, it's very fact specific. And it was a really sad, tragic outcome. So anyway, what had happened was our client had gone to a local Mexican restaurant for dinner several days towards the end after we were still in a state of emergency, but we'd had a lot of sunny days. The ice had melted in most areas. People are going back out to restaurants, things like that. And so this man and his family had gone into the Mexican restaurant for dinner, and it was one of their favorite local places to go as well. And they had seen while they were seated that there was some kind of an emergency type event. They could see the lights of the ambulance out in the parking lot, but they were seated towards the rear of the restaurant, didn't pay it a lot of attention. But then when they went to leave, this older gentleman goes out the front door, which was not the door he had entered from. There were two separate entrances and exits, and he immediately slipped on the ice. He fell back and he hit his head extremely hard. He actually fractured his skull and then developed a severe brain bleed. So it was a very significant injury. And so while he was lying there and his family's there and some employees came out and the EMTs came, they said, we were just here, 25 minutes ago. And so it turned out that another patron had gone out the same exit, slipped and fell on this ice and broke his leg. But then in the interim, no one took any steps to, lock the door, put a sign out, secure the area, put any salt down, nothing, which would have been such a simple thing to do, is just to block that door and have everyone leave out of the other exit. So because that had happened, Mike and I felt like it was a strong case that we could be successful on. So we partnered up together to bring it forward successfully.
Before you take another step forward on this story, I have to say I am floored. No pun intended. 2 people within like 30 minutes had the paramedics come out to the same restaurant where they had broken bones because of a slip and fall at this place's door. That is stunning.
Oh, Sarah and I went and met the family, and they were in a bad, bad way. And it was an elderly wife now caring for her elderly husband with a head injury. And the first thing this insurance company did for this restaurant was deny the claim. And the first thing they said was that, well, this man went in that way, and he came out that way. And if you do that, it's this prior traversal rule. You know, we were talking about a lot of defenses.
Prior traversal means
if you go through the area once and you do it successfully, you are typically barred from bringing a claim if you get hurt the second or third time you go through.
Oh, okay.
So we went to the restaurant, and we saw that that's actually not the way it works. You go in the one, it's purely an entrance, and then they make you leave out the other. So this man didn't go in and go out the way that they said. And then they had claimed later on that it was impossible to go out that area because they had some not fencing, but railings up. And then, we had realized that they put the railings up afterwards.
Wait, who said it was impossible to go? Who said there was
their attorney. And
so the attorney said this couldn't have happened because look at the fence right here.
Correct. But what he didn't realize is that we were there way earlier and had taken pictures, and the railing actually didn't exist at that time. And so this defense counsel just didn't go to this place. And so that was the difference is when they called us, we both got right into action, met with the family. Their attorneys went to the place, captured some evidence. And we were up against defense counsel, who are great defense counsel, but have a lot of cases. And certainly it became clear when we were meeting with them that they had never been to the place, never actually laid their own eyes on it. And so it gave us a great advantage in the case and ultimately allowed us to be successful for this very deserving family.
Yeah. And I think to your point, it is pretty shocking that this restaurant didn't take some very simple measures to make this area safe. And so that's what we were talking about earlier. They had prior knowledge of this dangerous icy condition because someone else had just been injured. And I think more shocking to us was it would just be such a simple thing to do, to lock the door, to send people another way. And I think in general we see that with a lot of these premises liability cases. It's not rocket science. It's just take a stroll. Yeah. Look for dangerous things that might not be readily apparent, but they're there and they're not that hard to find.
Did the business have any reason, I don't want to say excuse, but did they give any reason for why they didn't do something in that interim between when the first guy fell and broke his leg and when your client fell and had a hole in the back of his skull, a literal hole?
No, they that would be an admission against interest, and they will never do that.
Okay.
And so you have to prove that. You have to say, you mostly have to prove, well, this is what they could have done or should have done. And it becomes so obvious that these things are avoidable. You very rarely get the admission. And in fact, the one thing that angers me the most about these cases is a lot of this stuff is on video. And so when I first get the case, I say, give me the video, and they won't do that. And so, a lot of these things can be avoided if they just share video. Maybe we don't even have to bring a claim if they show me the video and it's not what I suspect it may be, which is an avoidable fall that horrifically hurt my client. But they not only won't give you the video, but you're not going to get an admission, unfortunately. So the only way to get an admission is to get a win for the family, and it's in financial recoveries.
Yeah. And we're going to get that video if we file a lawsuit. But like Mike said, sometimes there are reasons strategically where it doesn't make sense to go that route. And I have seen a couple of bigger stores too have started to at least allow us to see the video footage if it doesn't show what our client is telling us. And that is an easy way to avoid prolonging litigation or a claim that isn't valid. We don't want to do that. So that can be a win for both sides. I was going to say with this particular case, I do recall at one point having a conversation with the adjuster, I think before they got the defense lawyers involved. And they did try to argue to me that the restaurant couldn't get any salt because there was this ice storm in Atlanta and there was a shortage of salt. And even though it's not the right type of salt, Mike and I kind of jokingly said, well, they have salt for margaritas. Literally, if they had to put that salt down to melt this little patch of ice, because it wasn't a big area, it was just shady and it was right in front of the door. that they could have probably addressed it that way. So
Yeah, just take 10 minutes away from salting the rims and go
That's right.
outside.
exactly. But that was kind of a ridiculous argument.
Yeah.
They didn't make any attempt.
And I don't mean
it.
to make light of it because I know that your client was hurt so badly. I mean, the injuries were egregious.
Yeah.
Well, you go out to dinner and your life changes, right? On something that's completely avoidable, and that's on that I know that made us very angry and aggressive in response on behalf of him.
I know you guys pulled out all the stops too, and you constantly do for these cases.
No question.
Yeah.
Yes.
Yeah, and going to their home and meeting with the family, Mike and I took a pre-litigation deposition of this husband and wife, and it was really eye-opening to see she was just this tiny, petite woman. She was such a caring wife. She was, doing everything she could for her husband, but he was a bigger guy. And then because of these injuries, she was having to help him, just to lift him kind of to get into a standing position. And it was so difficult on them. And I think they'd been married like 50, 60 years.
Yeah.
And it was heartwarming to see just how caring she was. She was such a devoted wife, but it was also heartbreaking to see what they were struggling with in their last few years of life. And then tragically, our client did pass away shortly thereafter. We think we couldn't prove it was from this, some of the injuries compounded with other things, but it was a really sad situation.
Other health conditions that he had.
Yeah, with a
Or
brain
something.
bleed, for example, this was something we encountered. So a lot of older people are on blood thinners. Well, if you have a brain bleed, they don't want that blood, the thin blood to come into the brain and cause more of a bleed. So they're having to sort of weigh the risk and the benefit of being on the blood thinner.
Mm-hmm.
So he had to go off of the blood thinner due to the brain bleed. But then the fear was, now are you at risk for a blood clot and a stroke? And that was exactly what happened to him,
Oh,
unfortunately,
no.
a few weeks later.
Oh, just a few weeks later.
Yeah, and then that sort of led to a downward spiral with other medical conditions.
Do you argue then at trial or in settlement talks or whatever that but for this accident, this client would not be on his deathbed?
Yeah, oh, absolutely. And in this case, we talked earlier about being an invitee, right? They were inviting people to come for dinner. Well, if you can't provide a safe premises, then turn your lights off. Don't invite people, right? I mean, and so that would have been the but-for thing. Don't invite people if you can't provide a safe premise because of the state of emergency or whatever the condition may be. But the minute you turn your lights on and you invite people, you are telling them it's safe to come. And if it's not, then certainly we would hope that we could hold them responsible for that.
So I do want to point out here a stat that I got for you. The National Floor Safety Institute says slip and falls account for about 1 million trips to the emergency room each and every year. Again, I think we cannot emphasize strongly enough, this is not a joke. It's not a punchline. It can be a scam for some people, but that's usually borne out by the evidence. But we're talking about really serious injuries here. And when somebody is hurt that badly, to know that the laws are written, especially in a business-friendly state, to sort of help the businesses and attract the businesses, it's more of an uphill battle than you might think to try to get justice, to try to get made whole, to try to get your medical bills paid.
Absolutely.
Yeah, listen, I come from a family of trippers, right? My mom trips all the time. My father-in-law is a shuffler. Those aren't, when that happens to them, that's not cases, right? Cases are when they're owed a duty and there's a real defect that the owner knew about and it hurt the person. In the cases we've worked on, people are really hurt from these falls. I mean, there's broken legs, there's broken arms, thumbs, head injuries like we were just talking about. I mean, these falls cause really serious injuries that we typically see.
I think that when we come up in the MCA, the Motley Closing Argument is just ahead, maybe we can give a couple of tips, little pieces of advice to homeowners and business owners about how to protect themselves from such slip and trip and fall cases. That's straight ahead here on Lawyers in the House with Motley on WSB. Don't miss out. We are back in the house, Lawyers in the House with Montlick on WSB. I'm Veronica Waters here hosting Montlick injury attorneys Mike Moran and Sarah Root. We're talking about slips, trips, and falls today, and it's time for what you've been waiting for all hour long, the Mottlich closing argument. Sarah and Mike, take it away.
Yeah, so I think the most important thing is we practice across the country, and we want to know about these things as soon as they happen. So the key is call us right away. Let us get involved. You get an attorney who gets right on the case. You're not working with a call center. You get an attorney who starts to put into place a strategy. There's a lot of evidence that needs to be preserved, and it goes away rather quickly. So starting from the very beginning, talking directly with an attorney, coming up with a strategy, I think is huge in these cases because the evidence does need to be preserved. So that would be the biggest thing and the most important thing getting out of the gate, I think.
Yeah, I agree. Calling us, making sure you're hiring the right attorney from the get-go is critically important. But then on the flip side, for any business owners or small business owners that might be listening, I mean, ideally, we'd love to avoid having these injuries happen in the first place. And I think there's so many simple things that somebody who owns a business can do. It's not complicated. It's really just taking a look around. I was saying earlier, my family jokes and teases me that I'm like the safety patrol, but often when we go out to restaurants or things like that, I will see things that are so obvious to me, and I know it's just ripe for an injury. When my kids were younger, for example, we'd go out to this complex in Brookhaven, and there was a brick wall that had a piece of rebar just sticking out several inches right at my children's eye level, and it kind of blended in with the color of the brick. It was rusty. Then a few hundred yards later, there's this rusty old air conditioning bracket that was still there. And so those types of things, if you just look around and kind of intentionally go looking for them as the business owner to try to see what you may not notice otherwise, but if you're intentionally looking for it, trying to find those dangerous things, just remove them. Take care of it. It will prevent a lot of injuries in the long run.
Same thing we could say to homeowners too, because I'm thinking about what could be around my own house where somebody might either accidentally injure themselves or try to pretend like they did. So maybe check your yard for hoses, kids' toys, gardening instruments. I mean, we've all seen the cartoons where somebody steps on a rake, right, and it bangs you in the head. But that could be a real life injury. We've got to become our own safety patrols, really, around our own homes. Yes?
Yeah, we do. And we're inviting people to deliver things more and more online, right? So you have FedEx, you have Amazon coming to your home all the time. So you are inviting people all the time. And that's a great idea. Yeah. It just safety-proof your home, your yard. And for businesses, maybe invite your insurance underwriter out to your business. Have them walk around. Let somebody in their profession kind of tell you what maybe needs to be done.
Yeah, they want to protect you too. Thank you so much to Mike Moran and Sarah Root, Mottlich Injury Attorneys, for being in the house with us here on Lawyers in the House. I'm your host, Veronica Waters. Just remember, if you've ever been hurt in a slip, trip, and fall, don't you want the right attorney to stand up and fight for you? We'll see you next time on Lawyers in the House.